Hello and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we update you with the recent important legal developments across the nation. Here are the headlines. Day 10 of the Supreme Court hearing pleas challenging the abrogation of Article 370. Centre begins submissions today. Allahabad High Court adjourns hearing of the Krishna Janmabhoomi Shahi Idgah case till September 4th. Judge who ordered FIR against Chief Election Commissioner suspended by Telangana High Court. Collecting evidence is not the court's duty, NIA court observes in Malegaon Blast Case. Delhi High Court highlights the need to streamline process for issuance of passports to persons after sex reassignment surgery. Now let's take a detailed look at the headlines. A 5-judge constitution bench of the Supreme Court, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai and Justice Suryakant, heard the pleas challenging the abrogation of Article 370 for the 10th day today. The arguments by the petitioners were concluded yesterday. The Apex Court yesterday heard the arguments made by Senior Advocate Gopal Shankara Narayanan, Senior Advocate Nitya Ramakrishnan, Senior Advocate Menaka Guruswamy, and Advocate Varisha Farasat, along with others. Senior Advocate Shankara Narayanan posed the question, aren't we a democratic country run by a constitution? Do we not adhere to certain promises that we make, which are present in the constitution, on which 5 constitutional benches have weighed in? Or are we going to follow the example of people who put their PMs in jail, pointing out the political scenario of Pakistan? He also threw light on the judgment of Madhav Rao Scindia versus Union of India and stated that it had striking parallels with the present case, wherein the government invoked Article 366 to withdraw the recognition of rulers of the erstwhile princely states and abolish the privy purses. The Supreme Court overturned the move of the centre, and then the government amended the constitution to effectively implement its action. Mr. Shankara Narayanan in this regard said that I am taking these extreme examples to show that if they are allowed to do this, heavens know what else they would do. He also contended that the President cannot bring into effect irrevocable changes when a proclamation under Article 356 is in force. He also called the bifurcation of the state into 2 union territories as a downgrade. The top court yesterday observed that there is intrinsic evidence that Article 370 is of a self-limiting character, and it seems to have worked itself out after the term of J&K Constituent Assembly ended in 1957. From today onwards, the arguments on behalf of the centre began. Attorney General R. Venkataramani, Solicitor General Tushar Mehta, Senior Advocates Harish Salve, Mahesh Jethmalani, and Rakesh Dwivedi, Additional Solicitor General K. M. Nataraj, and others will be appearing for the centre in the coming days. Today, Attorney General R. Venkataramani submitted before the top court that on a combined reading of the instrument of accession and the proclamation, followed by the adoption of Article 370, all traces of sovereignty, if any, were surrendered. Constitutional integration of the process of the Union and J&K was the only object of Article 370. He further said that Article 370 was designed to aid the constitutional integration process on the same line as it happened with other states. Its continued exercise over a period cannot be seen as a distortion of its original purpose, and said that there was no deviation from due process while passing the presidential order. Solicitor General Tushar Mehta also commenced his arguments today and favoured the abrogation of Article 370 by saying that after going through the facts, it will be clear that a large number of fundamental rights and other rights will now be conferred upon the residents of J&K, and they would be fully at par with the rest of their brothers and sisters of this country. The Allahabad High Court today adjourned the hearing of a public interest litigation in the Krishna Janmabhoomi Shahi Idgah dispute till September 4th. A division bench of the Chief Justice Pritinkar Devakar and Justice Ashutosh Srivastav heard the PIL that sought the removal of the mosque which the petitioner claimed was built on the Krishna Janmabhoomi, or the birthplace of Lord Krishna. The petitioner also prayed for a scientific survey to be conducted by the Archaeological Survey of India under court monitoring. In an interim plea, the petitioner sought permission for Hindus to worship at the mosque premises on certain days of the week and during the festival of Janmashtami, which is Lord Krishna's birth anniversary. The Telangana High Court ordered the suspension of a special sessions judge for directing the registration of an FIR against the Chief Election Commissioner Rajiv Kumar and several others. The High Court said that the judicial officer, namely Judge Raghavendra Raju, acted in undue haste and did not conduct a preliminary inquiry or recorded the statements of the complainant. The High Court said that there was a serious lapse in the procedure followed by the officer while discharging his duties. The FIR was filed on August 11th against Telangana Excise Minister V. Srinivas Gaur and CEC Kumar along with several other officials for allegedly tempering Gaur's State Assembly election affidavit. The matter was referred to police by the Sessions Court on a private complaint which alleged that Gaur, who is an MLA from Mehboob Nagar, tempered with the election affidavit by suppressing facts. The Special NIA Court, short for National Investigation Agency, made an interesting observation in the 2008 Malegaon Blast Case. The Special NIA Court Judge A.K. Lahoti said that it is the duty of the prosecuting agency to collect evidence and not that of the court. The observation came while the court was hearing an application filed by a witness who urged that a CD of a meeting held in Bhopal in 2008 by the right-wing organization Abhinav Bharat, where the conspiracy allegedly took shape, be produced before the court. And he also sought a direction from the court to the ATS in this regard. The case relates to the blast in Malegaon in 2008, when a bomb strapped to a motorcycle allegedly belonging to Sadhvi Pragya took off and killed a few and injured several. The prosecution alleges that the then Lieutenant Colonel Prasad Purohit was part of the meetings of Abhinav Bharat, where the conspiracy was hatched, and so the material relating to such meetings be placed before the court. The court rejected the application and made the observation that the investigating agency is duty-bound to produce before the court the documents in its possession, but a witness or an accused cannot ask the court to call for such documents. Justice Subramaniam Prasad of the Delhi High Court, while hearing a petition by a transgender woman for reissuance of her passport with revised particulars after undergoing sex reassignment surgery, made the observation that the process for the same needs to be streamlined. Justice Prasad said that transgender persons who choose to undergo sex reassignment surgery face difficulties in acquiring fresh passport due to change in appearance, an issue which needs to be streamlined. The petitioner, who was a male at birth, moved to the United States in 2018 after securing employment and transitioned from a man to woman between 2016 to 2022 and thereafter legally had a change of name and gender by way of a court order in the United States, where the transition took place. She then submitted an application before the Indian authorities in January this year for reissuance of a passport with changed particulars. The application, however, has been pending all these months. The Counsel for the Ministry of External Affairs and Consulate General of India in Chicago, USA, submitted that the application of the petitioner has been processed and the police verification is pending. The counsel urged the court to grant him more time to get better instructions in the matter. The court granted time to the centre's counsel and scheduled the matter for further hearing on August 28th. That was all on today's legal news. Thank you and keep watching Verdictum. And subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.